Hello, this is Professor G. This week, which is actually week 7 of our 8-week course, I will focus on intellectual property. First process in setting up a business in the real world is choosing a name for the business that you can protect. Vetting a business name. This is a process that I came up with years ago after working with a number of small startups that had gained some success, only to find out that the business name that they had chosen was owned by somebody else. Somebody else had claimed a registered trademark in it. So, and I'll give you one of the best examples. I had a couple students who started a very successful business and in Michigan. And as they're about to scale and grow significantly, they found out that there was a business that had trademarked the name on the East Coast. No way to get around it. They had to essentially pause their business, completely rebrand, rename every aspect of their business, redevelop their website, all the marketing promotion materials, etc. So incredibly costly mistake on their part. How do you avoid that? Well, first, why does it matter? Again, the students that I was talking about, they're threatened with litigation. Okay. And then there's simply the cost of having to start over. The first thing you do is in your given state, whatever state that is. In Michigan, there is the Michigan Department of Corporations, Business Entity Search. If you click on that link in the PDF file, which will be in our week 7 folder, you'll come to a search page and you simply type in the name of the business and you'll see if somebody else in your state already operates an identical or similar business in terms of naming. Restricted words. I do want to caution you on this. Every state will have a list of names which are no-nos, meaning you cannot freely use them in your business. In Michigan, I think that list is about 400 words that have some type of legal restriction placed on them. I'll give you an example. You cannot use the word apothecary unless you are licensed as a pharmacist in some way, a pharmacy. So if you want, I recently met with somebody who wanted to open an apothecary, meaning have the name apothecary something. They weren't going to sell any type of pharmaceuticals, but it didn't matter. The term apothecary is synonymous with pharmacy. I also run into entrepreneurs who like the term trust. Personal services business, very often they'll want to include the name trust in the business. And in most states, that's prohibited because that is synonymous with a bank and trust, etc. So it's not automatic that the name that you want is available. First, is it available? Meaning, is it not already owned by somebody else? And second, does it comply with whatever the naming regulations are in your state? Where does the vetting process begin? A simple internet search, a search engine check. I meet with I think the majority of entrepreneurs I meet with have not simply put the name that they want for their business in a search engine and hit enter to see if anything pops up. Now, if you choose, and I'm just going to use a good example because I'm not feeling super creative today, but if I choose Acme and I put that in a search engine, it's going to pop up many times. Many other businesses will show up. That is not the end of that name. It's not dead to you. There's more that you can do. I mean, you can look at context. If you were to find out, for example, that Acme had been trademarked in the manufacturing space, it might be available to you in the restaurant space. But let's set that aside for the trademark discussion that we'll get into. But the first place you go to is search engine. If you have a name for a business that you think is innovative and creative and you find out that there's 300 other businesses with a similar name, probably time to start looking for another name. Domain name search. I got burned once many years ago starting my first business. I had a name for the business picked out, and I was just searching to see if the domain would be available. So I went to a site that sells domains, put in the name that I wanted, said it was available. Nobody else in the world had claimed it or anything similar to it. I went back several weeks later because I was just cruising domain search engines and wasn't really 100% decided on that name. And I found out 3 weeks later when I searched again that somebody in Wisconsin had purchased that domain and that it was for sale for, I think, $3,000. Same search engine, 3 weeks prior, nobody had the name. It was freely available. One conclusion, there's an algorithm out there that they're using to determine whether or not there's a demand or a need or a want for a domain. Companies are buying them and selling them to you at an elevated price. So here's my point. Do not search for a domain name availability until you are absolutely ready to purchase at that very moment. The U.S. Patent and Trademark Office, or the USPTO, this is where we officially register trademarks. That, an officially registered trademark looks like this. It is the R in the circle. You'll see it quite often. Now, it is not required that you search the USPTO to start any business. However, it is advisable because, again, do you want to invest time and money developing a business only to find out later that somebody else has registered the trademark? It's very easy to search. There's a system. You go to the USPTO website. You look at TESS, T-E-S-S. There's a link here. Type in the keywords, and you'll see a list of similar names, identical names, etc. And from there, you start the due diligence of how close is your name to an existing registered trademark. The significance of intellectual property, or IP. IP is any product of human intellect that is intangible. You can't touch it, but has value in the marketplace. Why is it important? Historically, businesses, their value was in physical assets, inventory, machinery, etc. But today, value is in ideas, intellectual property. So securing your intellectual property early is of great importance for any business. An IP audit. This is a 2-step process I developed. The first step is determine whether the intellectual property in question is related to the firm's competitive advantage. Does it make you different? Does it make you unique? Does it make you attractive to customers? Okay, if so, it definitely has IP value. And then what about marketplace? Does your competitive advantage, this IP that's tied to your competitive advantage, have value in the marketplace? Meaning, is it attractive to other competitors? But then even go a little bit further. For how long? And so if this is intrinsically part of our competitive advantage, it's got a long life in terms of value. But if it is a tech item that we're developing, like software, that's probably going to have a 2 to 3 year market value, meaning in 3 years it'll be obsolete. You have to debate whether or not you want to invest a ton of money in protecting the asset, because it'll take a year to get the protection that you want. And so do you spend all that time and money protecting a 2-year shelf life product when you could invest that money in research and development, developing new products to replace the one that you believe will sell great, but only for 2 years? Before you sit down and talk to anyone about your ideas, it's not a bad idea to have them sign a confidentiality agreement. I put a simple short form confidentiality agreement in the Blackboard folder, week 7. Simply says that before I talk to an accountant, an attorney, an advisor, that they agree to keep your idea confidential. Now, some will say, I'll never sign something like that. My response is, then go to somebody else. What is the issue with signing a confidentiality agreement? I have seen entrepreneurs get burned when they go and talk to professional advisors, and that professional advisor shares the idea with somebody else. Common IP mistakes. There's really 4. Number 1 would simply not identifying IP. You're so busy in your business that you don't identify or recognize the value of your IP. I did that early in my career. I had developed actually some software. Was so busy using it because I actually used it in my business. I failed to protect it, caused me financial harm later. And then I did it again shortly thereafter with another item of intellectual property that I developed. That one I lost all entirely. It just got away from me and somebody else took it and ran with it. So not identifying your intellectual property, not recognizing the value, not protecting it, and not recognizing that intellectual property is an integral part of our plan for overall success. There's 4 general forms of IP or intellectual property. We have patents, trademarks, copyrights, and trade secrets. What are patents? Patent is a grant from the federal government conferring the rights to exclude others from making, selling, or using an invention for the term of the patent. So essentially, when I send in a patent application saying, here's my idea, this is what it looks like, this is how it would work, and the government says, we are going to grant your application for patent, and you are awarded a, let's say, 20-year patent. That means for 20 years, I have the exclusive right to produce, manufacture that product. Okay? Now, the government does not enforce it. So if somebody else is in violation of my patent right, I have to pursue them. But we'll talk more about that later. How long does a patent take? 22 to 33 months for a full patent. How much does it cost? It can vary. Low end, simple patent, maybe $5,000. More sophisticated patent, easily $14,000. What about a provisional patent? If you do it yourself, it's less than $100. And that's a short-term, 12-month bridge to a full patent, which I'll talk about another time. So patents have 3 main requirements. A patent, an idea that you have, must be useful, must be novel, and it can't be obvious. So if you have the most valuable idea in the world and you're certain it's going to make you millions of dollars, you send in your application. A U.S. Patent and Trademark Office patent reviewer, who's likely an engineer or an expert in the area that your patent falls in, might look at the application and say, yeah, it's pretty cool, but you know what? That's too obvious. You don't get a patent. Or it's not useful, doesn't have a utilitarian value. So these are the 3 big areas: useful, novel, not obvious. Now, types of patents. First patent we're going to talk about is utility patent. It means it actually does something. New or useful process, machine, manufacture, or composition of material, or any new and useful improvement thereof. It's actually got to do something. It's a new process of manufacturing, making. It's a new machine. It's a new type of infrastructure. It has a physicality. The length of the patent is 20 years from the date of issue. What about a design patent? Invention of a new, original, and ornamental design, and that's it. Ornamental. Doesn't do anything. And so, for example, I explain this. Sometimes you'll see like a Ford Mustang that'll have a hood scoop on it, and it's purely ornamental. There's not a blower in the engine compartment. When you look closely at the hood scoop, it's not intaking any air. It simply makes the vehicle look really cool. How long is a design patent? 14 years. You can actually get a patent on a plant. So if you're going to develop a new hybrid corn, for example, that is drought resistant, disease resistant, you can actually get a patent on that. And it's 20 years. Business method patents, which is a form of a special utility patent, which means it's a 20-year patent. How can I best explain this? Amazon one-click checkout. Amazon, prior to Amazon, and e-commerce was not new, but to check out, it was a process, a multi-step process. So Jeff Bezos and his team come up with this idea for their e-commerce platform, which is now Amazon, that you would be able to click once and actually check out. They applied for a patent, arguing that this was an innovative business application, a process, and they were successful and secured a 20-year utility patent. Now, this is not easy to obtain, a business method patent, but think about that. For a period of 20 years, anyone that wanted to use one-click checkout had to pay Amazon a licensing fee to do that. So they had the market on one-click checkout, or any version of it. You didn't have to call it one-click checkout because it's actually the process that they patented. So very important. If your business creates a new process or new system, sit back and view it from a critical perspective. Is this something, this process, something which we might be able to patent and give us a competitive advantage? What is the patent process? You want to make sure that the invention is practical. Document when the invention was made so that if there ever becomes a dispute over who made it first. Hire a patent attorney. You need expertise. This stuff's not easy. Conduct a patent search to see if there's any conflicts. File a patent application. And then you get the final decision from the U.S. Patent and Trademark Office as to whether or not it's been approved. What about patent infringement? I see this on both ends. I see people who just completely disregard patents and go forward with their business, and they could be sued for patent infringement, meaning somebody else has patented the product, the design, etc., and your product, your design is very similar, so similar that the average consumer would not distinguish the two. And so you could be held liable and sued for monetary damages and other damages for an act of patent infringement. How much do these cases cost? Now, here's the hard part. If I have a patent and I see you are infringing upon my patent rights, I must hire an attorney and file a civil suit against you, and that's not inexpensive. So for cases with damages around 1 to 10 million, the cost of fighting this thing out in court could be $1 million. If damages or the dispute is valued at about 25 million, it could cost us about $4 million to process this case. I mean, you're going to need $50,000 cash to retain an attorney just up front to file a patent infringement case. So patents are great. Patents will not immediately make you rich. Patents are attractive to investors, but patents are not inexpensive when we try to enforce them. So always look at the value of the IP in your entity, no matter what it is, and take steps to protect your IP. And good luck with your new venture.